Second, finality is a concept fundamental to the administration of justice. And all the arguments, debates, considerations referred to in the program for this conference point to a sensitive area of potential conflict between the notion of finality and the status of victims. And here, permit me to make a remark in the light of something that Dr. Doak said in his concluding comments about the adversarial system. That it is not the ideal system, I think everyone, whether lawyer or otherwise, in the end will have to acknowledge. The best description of the adversarial system I have ever heard was given by a former Governor of New South Wales, a former member of my court, and a lawyer of the highest reputation and esteem. And he said at a judges' conference, and I do not remember whether he said this as words of his own or as repeating someone else's statement, this, that the adversarial system evolved not to determine truth, but to find a winner. And after many years of continuing reflection, I think that proposition is inherently sound. The third of my guiding principles is a vigorous act of self-defence, I suppose. It is false to assert that judges really don't know anything about what goes on in the real world. The concept of the ivory tower is defunct. Judges live in the community. Judges are subject to the same stresses, influences, sources of information and misinformation, the whole passing parade of the good and bad as everyone else in the community. Further, their professional careers usually have brought judges into contact with just about everyone in just about every situation founded in conflict. And finally, as judges, we see it all. We are imperfect and flawed members of the human species, as is everyone else. If there is an ignorance factor, it is the other way round. There are some who do not know how ordinary and worldly judges in fact are. Those who enjoy that ignorance are probably incurable because they are, to my experience, radio commentators and the remnants of Grub Street journalism. The fourth in this catalogue of concepts and principles, and here I wish to use a very fancy word, the meaning of which is not quite clear to me, but finally in this taxonomy is this proposition: the most premeditated, carefully planned, conscious and conscientiously deliberate but egregiously futile act of homicide is capital punishment. Forget it. I would be saddened indeed if that topic was raised in any way as a remedy for anything or anyone in the context of this gathering. So, I come to the substance, such as you will judge it to be, between the bookends or on the continuum, supported by the principles. As a district court judge between 1987 and 1992, a long time ago I've just reflected, I cannot recall any consciousness of victims solely as victims or at all. As the attorney remarked in his opening statement this morning, the victims were mere witnesses whose testimony as to violent events was principally given for the determination of the issue of guilt. Nonetheless, their evidence played a part in the characterisation of the gravity of the offence, as it still does, for sentencing following conviction. During those years, so long ago, the sentencing process was far shorter. Reasons for sentence were usually contained in 3 pages rather than the 30 plus now seen in sentences emanating from the district court in the 21st century. The growth in the prosecution of sexual offences during my time in the district court, upon reflection, did heighten both my natural human concern, especially as a father with 3 young kids, and challenged my credulity from time to time as to how such conduct, about which I heard evidence, came to be committed at all. Otherwise, the load of the business of the district court meant a tide of cases, each to be dealt with, and from each one, movement to the next. My 5 years in that court proved to be a demanding and exhausting judicial and personal experience and development, especially in the management of all the human components, and all components in the justice administration system are human, even members of the bar. Thus, then, and now, I suppose it might appear that judges do enjoy a privileged, uncaring, unmovable detachment. The reality is really quite otherwise. Keeping natural human reactions, responses, preferences and prejudices under control and non-influential is as exhausting as it is necessary. The politicisation of the criminal justice system in this state, to my mind, first manifested itself by legislation in 1989 with the Sentencing Act, which sought to establish truth in sentencing. In 1996, legislation expressly concerned with victims was enacted in the Charter. More recently, the excruciating Crime Sentencing Procedure Act of 1999. More recently, and for me philosophically quite troubling, legislation known as the Crimes Serious Sex Offenders Act 2006, which, as you know, provides for applications to the court for the extension of either custody or supervision. There have been murmurs, at least, that similar legislation, which presumably will be called Crimes Serious Violent Offenders Act, is under consideration, and in respect of which I have the same reservations. Why? Because these kinds of laws challenge traditional principles as to finality, double jeopardy, already under siege, and equality before the law. However, disturbing though I think these developments may be felt to be, as long as the courts are not bureaucrats or jailers, special interest groups or special pleaders are the determining bodies, all might prove to be of benefit rather than danger if the proposals eventuate. All the matters I've just been through affected me as a Supreme Court judge from 1992 to 2005. During that period, especially the Revolution at least, heightened public interest in the administration of justice, public attention to it, and of particular relevance, public attendance in the courtrooms. The physical presence in the courtroom of support persons, support groups, victims support camps, offenders support camps, and occasionally the noise from the outside group of protesters on the street. None of those made or makes the subsuming of the judge's persona to the judge's judicial role any the easier. In the Supreme Court, the stakes are higher. Ultimately, the loss of liberty for the whole of the offender's remaining natural life. The adversaries I found to be more gladiatorial, and the legal and factual elements more excruciating in their technicalities. I am frankly unimpressed by repeated statements by highly respected members of the judiciary or from the academic world about, dear oh dear, the law has become so complex, so very, very complex in the late 20th and early 21st century that it's all too hard for members of the community, especially juries. What I like to hear is a voice speaking equally as loudly saying what we should try to do to maintain the vital constitutional role of public participation as jurors in the administration of justice, rather than get rid of them, get rid of the technicalities. And when I hear that loud voice saying words that to that effect, it is, alas, usually my own.